Welcome to Season Synopsis.
Hello and welcome to the next session of decoding the judgments passed under Prevention of Money Laundering Act. Today we dive into a turning point in the legal world of Prevention of Money Laundering Act by reflecting the judgment passed by the Honorable Supreme Court of India in the case of Pankaj Bansal versus Union of India. In under 10 minutes, I will attempt to unfold the questions raised before the Honorable Supreme Court of India, the submissions by the counsels appearing for the accused, as well as the submissions by the counsels appearing on behalf of the prosecution, and touching upon the constitutional questions that the Honorable Court addressed and answered. So let's dive into it. Let me start with the prosecution submissions. The case of the prosecution or the authority under PMLA was that the arrest of the appellant or the appellants in this case, that is Pankaj Bansal and Basant Bansal, were legal. As per the prosecution, the procedure under section 19 of the PMLA was followed to the letter. Their next leg of submission was that the grounds of arrests were in fact communicated verbally and immediately over the phone to the concerned family members. The written grounds were also read out aloud in Hindi in the presence of witnesses. And crucially, when the appellant refused to sign, it wasn't because he was not informed, but he simply did not want to acknowledge it. As per the prosecution, the procedure followed by them met the parameters of the law. Section 19, as per the prosecution, only required that a person be informed of the grounds, but not necessarily in writing. They relied upon the previous judgment like Vijay Madanlal Chaudhary in support of the condition. Let us now briefly understand the submissions put forth by the defense. The appellants did not challenge the constitutionality of section 19 as that had already been upheld in the previous judgments. Instead, they prayed to the Honorable Court to read it down. The expression reading down simply means interpret in a way that strengthens the fairness and the contours of the provision, the length and breadth of the provision. The appellants argued that the authority under PMLA did not provide a written copy of the grounds of arrest, and therefore there was an inconsistent practice with respect to the same which violated the provisions of section 19 of PMLA as well as article 22 subclause 1 of the Constitution. It was the contention of the appellants that informing the concerned arrestee about the grounds of arrest, especially in writing, would enable them to have a fair representation in the Honorable Court. The second point was, which developed the first submission, was that they would be better equipped to apply for an appropriate legal remedy if they understood their grounds for arrest, in the absence of which they will not be able to fully adopt the legal remedy available to them under the four corners of law. Another broader point was made by the appellants. that failure to admit to the allegations would not amount to non-cooperation under the relevant Constitution of India and or any other law. The Honorable Supreme Court observed 3 to 4 essential points of law. The Honorable Court observed that the orders of remand by the learned special court or learned magistrate court must reflect an application of mind. It must reflect whether there has been appreciation of facts and whether there has been an application of mind independent to the materials before it. The court further said that just because an individual does not confess during interrogation would not automatically imply that they are uncooperative, as it violates Article 20, Subclause 3 of the Constitution of India. With respect to the issue of grounds of arrest and the fact that they must be in writing, the court observed that verbal information was not enough. There must be written grounds of arrest, and the court said so to ensure a uniform practice across the India, and further that when an arrestee is under arrest, he is not in a mental state to process oral information. And the third essential point that the Honorable Court raised and answered is that written grounds ensures fairness and prevents any abuse of process of law. Therefore, the Honorable Supreme Court, in view of the brief discussion above, set aside the arrest orders, the arrest memos, and the remand orders by the learned special court.